Iowa has a well-structured lease termination framework that benefits from the state's adoption of the Uniform Residential Landlord and Tenant Law. The governing statute is Iowa Code Chapter 562A, and it provides clear procedures that both landlords and tenants must follow. If you manage rental property in Iowa, the process is detailed but predictable, which is exactly what you want when navigating a termination situation. Let's start with no-cause termination. For month-to-month tenancies, Iowa requires either party to provide at least 30 days written notice before the end of the rental period. The notice must be delivered at least 30 days before the next periodic rental date. So if rent is due on the 1st and you want the tenancy to end on the last day of March, you need to deliver notice by March 1st. For fixed-term leases, the lease expires at the end of the agreed term. Iowa does not require additional notice for the natural expiration of a fixed-term lease, unless the lease itself contains a renewal or notice provision. If the tenant remains after the term expires and the landlord accepts rent, the tenancy converts to a month-to-month arrangement under the same terms. Landlords who want to avoid this automatic conversion need to communicate their intentions in writing before the lease expires and stop accepting rent after the term ends. For week-to-week tenancies, Iowa requires 10 days notice from either party. This is slightly longer than the 7 days most states require for weekly tenancies and is specific to Iowa, so landlords with weekly arrangements need to keep this in mind. Now let's cover termination for cause. For non-payment of rent, Iowa requires the landlord to provide a 3-day notice to pay or quit. Under Section 562A.27, the landlord must deliver written notice giving the tenant 3 days to pay the full amount of rent owed. If the tenant pays within 3 days, the notice is void and the tenancy continues. If the tenant doesn't pay, the landlord can file a forcible entry and detainer action in small claims court or district court, depending on the amount involved. Iowa's 3-day non-payment window is one of the shortest in the country. The notice must clearly state the amount owed and the deadline for payment, and it should be delivered by a method that can be documented. Iowa courts will scrutinize the notice for accuracy and proper service, and any defect can result in dismissal. Here's something important about Iowa's non-payment process. The state allows the tenant to exercise a right of redemption by paying the full amount owed before the eviction is carried out. However, Iowa limits this right. If the tenant has been through the non-payment process and redeemed once within the preceding 12 months, the right of redemption is extinguished for the remainder of that period. This limitation prevents chronic non-payers from repeatedly using the redemption right to avoid eviction, while still protecting tenants who face a one-time financial crisis. For lease violations other than non-payment, Iowa uses a 7-day notice to cure, followed by a termination. Under Section 562A.27, the landlord must provide written notice specifying the violation and giving the tenant 7 days to correct it. If the tenant cures the violation within 7 days, the notice is void and the tenancy continues. If the tenant doesn't cure, the landlord can proceed with filing for eviction. Iowa's 7-day cure period for lease violations is shorter than many states that provide 14 days or more. This gives Iowa landlords the ability to address violations more quickly than in states with longer cure windows. However, the notice must clearly identify the specific violation and what the tenant needs to do to fix it. Vague or overly broad notices can be challenged in court. For repeated violations of the same type, Iowa has a specific escalation provision. If the same violation occurs within 6 months of a prior notice, the landlord can terminate the rental agreement with a 7-day notice without providing another opportunity to cure. This is a powerful tool for landlords dealing with tenants who repeatedly commit and cure the same violation. The second time around, there's no second chance. For serious violations, including criminal activity, drug-related offenses, and conduct that creates a clear and present danger to other residents, Iowa provides a 3-day notice to quit with no opportunity to cure. Under Section 562A.27a, if the tenant or someone under the tenant's control commits a serious criminal act on the premises, the landlord can serve a 3-day notice requiring the tenant to vacate. There's no cure period because the violation is so severe that continuing the tenancy is unreasonable. Iowa's statute specifically identifies certain violations that qualify for the 3-day no-cure notice. These include the manufacture, delivery, or possession with intent to deliver a controlled substance on or near the premises, discharge of a firearm in violation of law, acts of violence or threats of violence against other residents or neighbors, and activity that creates an immediate threat to health or safety. This enumerated list gives landlords clear guidance on when the expedited process is available. Iowa also has a specific provision addressing situations where a tenant's conduct constitutes a clear and present danger. Under Section 562A.27a, the landlord can file for a temporary injunction requiring the tenant to vacate immediately if the tenant's behavior poses an imminent threat to the safety of other residents. This emergency remedy goes beyond the standard eviction process and allows the landlord to seek immediate court intervention when the situation is truly dangerous. The eviction process in Iowa goes through small claims court for most residential cases, though larger claims or more complex situations may be filed in district court. The landlord files a forcible entry and detainer action after the applicable notice period has expired. The court schedules a hearing, typically within a few days to 2 weeks of filing. Iowa's small claims process is designed to be efficient and accessible, and cases typically move through the system at a reasonable pace. At the hearing, the landlord presents evidence supporting the grounds for eviction, and the tenant has the opportunity to respond. Iowa courts allow tenants to raise defenses including improper notice, the landlord's failure to maintain habitable conditions, retaliatory eviction, and discrimination. The habitability defense is significant in Iowa. If the tenant can demonstrate that the property has unresolved defects that the landlord knew about, the court may deny the eviction or reduce the rent owed. If the court rules in the landlord's favor, a judgment for possession is entered. The tenant then has a specific period, typically 3 days, to vacate before the landlord can request a writ of removal. The sheriff carries out the physical eviction. The overall timeline from filing to removal is typically 2 to 4 weeks for uncontested cases, making Iowa one of the more efficient states for the eviction process. Iowa allows the landlord to seek damages in the same action, including unpaid rent, property damage, and reasonable attorney's fees. Combining the possession and damages claims saves time and legal costs. One aspect of Iowa's framework that landlords should understand is the state's approach to abandoned property. Under Section 562A.29, if a tenant leaves personal property behind after vacating, whether voluntarily or after an eviction, the landlord must follow specific procedures before disposing of it. The landlord must hold the property for a specified period and make reasonable efforts to notify the former tenant. After the required period, the landlord can dispose of the property in accordance with the statute. Failure to follow these procedures can result in liability for the value of the disposed property. Iowa also addresses the issue of lease abandonment itself. Under Section 562A.28, if a tenant abandons the property without notice, meaning they leave, remove most belongings, and stop paying rent, the landlord can treat the lease as terminated. The landlord should document the abandonment carefully and make reasonable efforts to re-rent the property to mitigate damages. The former tenant remains liable for rent until the unit is re-leased or the lease term expires. On the tenant side, Iowa provides several grounds for early termination. If the landlord fails to maintain the property, as we covered in our Iowa habitability video, the tenant can provide notice and allow the landlord 7 days to make repairs. If the landlord doesn't act, the tenant can terminate under Section 562A.21. For essential services failures, meaning no heat, no water, no electricity, or no gas, Iowa provides additional remedies under Section 562A.23. The tenant can give reasonable notice and then procure substitute housing at the landlord's expense, recover damages based on diminished rental value, or procure the essential service and deduct the cost from rent. These remedies are available in addition to lease termination and provide tenants with immediate practical options when critical services fail. Active duty military members are protected by the Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. Iowa has Camp Dodge and the Iowa National Guard headquarters, along with military families associated with installations in neighboring states, making this provision relevant in the state. Iowa provides early termination rights for victims of domestic abuse under Section 562A.27b. A tenant who is a victim of domestic abuse, as defined by Iowa Code Chapter 236, can terminate the lease by providing written notice along with documentation. Qualifying documentation includes a valid protective order, a police report, or a written statement from a qualified professional, such as a domestic violence counselor, social worker, or medical provider. The tenant must provide at least 30 days' notice before the termination date. The landlord cannot charge early termination fees or penalize the tenant for the early termination. Iowa's domestic violence provision also includes a lock change right. If the perpetrator is not on the lease, the tenant can request that the landlord change the locks to exclude the abuser, and the landlord must comply within a reasonable time. If the perpetrator is on the lease, the process is more complex and may require a court order removing the perpetrator from the tenancy. Iowa also provides early termination for tenants who are victims of sexual abuse under similar provisions. The documentation and notice requirements parallel those for domestic abuse situations. Iowa strictly prohibits self-help evictions. Under Section 562A.26, landlords cannot change locks, shut off utilities, remove doors or windows, remove the tenant's belongings, or take any action to force a tenant out. The penalties are significant. The tenant can recover actual damages and up to 2 months' rent, whichever is greater, plus attorney's fees. Iowa courts enforce this prohibition consistently, and self-help tactics will destroy a landlord's credibility in any subsequent legal proceedings. Iowa's anti-retaliation protections are found in Section 562A.36. Landlords cannot increase rent, decrease services, or file for eviction in retaliation for a tenant making a good faith complaint to a government agency about code violations, complaining to the landlord about habitability issues, or organizing or joining a tenant's organization. If adverse action is taken within 1 year of the tenant's protected activity, there is a rebuttable presumption of retaliation. Iowa's 1-year protection window is one of the longest in the country and provides tenants with extended protection after exercising their rights. One practical consideration for Iowa landlords: the state's agricultural economy creates some unique rental dynamics. Many Iowa rental properties are in small towns and rural communities where the rental market is smaller and more personal than in urban areas. Landlord-tenant relationships in these settings often rely on communication and mutual respect as much as legal procedure. That said, following proper legal procedures for termination is essential regardless of the setting. Even in a small town where you know your tenant personally, documenting notices and following the statutory process protects you if a dispute goes to court. Iowa requires landlords to return the security deposit within 30 days of the tenant vacating the property. The landlord must provide an itemized statement of any deductions. If the landlord fails to return the deposit or provide the statement within 30 days, they may be liable for up to twice the amount wrongfully withheld. Iowa limits the security deposit to 2 months' rent, and the landlord must hold the deposit in a bank or credit union account, though the statute does not require a separate escrow account. For the complete guide to Iowa lease termination laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our series.